guys, welcome back to Legal Banter. 2020 was an unforgettable year because of the corona and the pandemic. But that did not deter the Supreme Court from coming out with certain landmark judgments. This video will be a quick recap of the various landmark judgments that came out from the Supreme Court in the year 2020. I know it's a little late, but there I durust hai. This video will be extremely useful for CLAT aspirants, existing law students as well as IS aspirants for their current affairs preparation. The first case is Anuradha, Bhasin and another versus Union of India. This case was a landmark case because the court for the first time recognized the right to internet. The court held that the indefinite ban on internet and related services in the state of J&K was unconstitutional as it violated not only their rights under Article 21 but also under Article 19, which pertains to freedom of carrying out any trade, business or profession. The next case is Sushila Aggarwal versus State of NCT of Delhi. In this case, the court held very specifically with respect to section 438 of the Code of Criminal Procedure that pertains to anticipatory bail. The court held that the protection that was granted to a person under the said section should not be limited to a particular or a fixed time period, and therefore whenever there would be a doubt should always be read in the favor of the accused. The court further stated that the protection of the anticipatory bail does not cease to exist once the accused is summoned but may also continue till the conclusion of the trial. So this was an important case so far as it came to rights of a accused. The next case is the case of Kantaru Rajeevaru versus Indian Young Lawyers Association through General Secretary. In this case, the court, while hearing the Sabarimala reference decision, held that the Supreme Court does have the power to refer questions of law to a larger bench while it is exercising its review jurisdiction therein. This case was an important case because it allowed further powers to the review jurisdiction of the Supreme Court. The next case is Pandurang Ganpati versus Vishwasrao Patil Murgad Sahakari Bank. This case was important because the Supreme Court herein held that the SARFAESI Act will also apply to cooperative banks. Similarly, it applies to other commercial banks as the word bank under the SARFAESI Act also applies to such banks. The next case is the case of Chebrolu Leelaprasadrao versus State of Andhra Pradesh. In this case, the government, while hearing a challenge on the government of Andhra Pradesh order whereby they had allowed for 100% reservation for tribal teachers in scheduled areas, was held to be unconstitutional. The court held that there was no reason, rhyme or otherwise, to consider that such a requirement could ever be mandated under law. The next case is Christian Medical College Vellore Association versus Union of India. In this case, the court held, while hearing a challenge and understanding the scope of Article 30 of the Indian Constitution, the court declared that Article 30 does not vest an absolute right on the religious and linguistic minorities to administer educational institutes as per their choice. The court held that such a right does stand to being regulated by the state. As a result of this, the court held that while it was making NEET, the exam of NEET, mandatory and applicable to private minority unaided professional institutes in order to seek admissions for various medical courses, no fundamental rights under Article 30 would stand violated. The next case is Amit versus Commissioner of Police. The court in this case held that democracy and dissent does not go hand in hand. On one hand, a person does have a right to carry out strikes or protest or even gather for the same as a part of its fundamental rights. The same cannot be allowed to infringe upon a fellow human person's right. The court held that the Shaheen Bagh protest, whereby public spaces had been occupied, the same could not be allowed to go on indefinitely because it did cause public inconvenience. The next case is Skill Lotto Solutions versus Union of India. In this case, the court upheld the imposition of GST on sale of lotteries, considering that the Central and Central Goods and Services Acts and the notifications thereunder had tried to bring lottery and such gambling under the provision, and the same stands to be valid. The court's basis for this decision was on the basis of definition of goods under Article 366, whereby it stated that it is inclusive and there was no intention that could be manifested to give any restriction on the word of the meaning of goods. The next one is quite a popular case. In the case of Riya Chakrabarti versus State of Bihar and others, the court, while invoking the plenary jurisdiction under Article 142, upheld the FIR that was registered with the Bihar police. As a result, the court ordered the Maharashtra police to hand over the evidence and the investigation happened so far, and also ordered them to assist the CBI in the case relating to the death of Bollywood actor Sushant Singh Rajput. The next case is Abhilasha versus Prakash. The court in this case held that a Hindu unmarried daughter was entitled to claim maintenance from her father under the provisions of section 125 of CRPC. The next case is S. Skashi versus State Through Inspector of Police. The court therein held that extending limitation and the lockdown order of the government has no effect on the right of an accused to seek a default bail under section 168 clause 2 of the Code of Criminal Procedure. The court, while doing so, quashed the order of the single judge of the High Court, wherein it had been held that such an order could not be made. The next case pertains to an unfortunate event that happened last year, which was the Hathras case. In the case of Satyama Dubey versus Union of India, the court held that in order to allay all apprehensions and only as a confidence building measure, held that the Allahabad High Court had to monitor the CBI probe into the case. The court also directed that the security to the victim's family and the witnesses in the said case should be provided by the CRPF therein. The next case is an interesting case. In the case of Arnab Goswami versus State of Maharashtra, the court allowed the release orders for Arnab Goswami by granting him the bail. In its judgment, the court also read that the Bombay High Court, while accepting such a late petition, had abdicated its constitutional duty as a protector of liberty by refusing to grant relief to the person. It also observed that it could not be held that the petitioner had abetted the suicide of the deceased person. The next case could be a very useful one. In the case of Paramveer Singh Saini versus Baljit Singh, the court directed all the states and union territories to install CCTV cameras in each and every police stations, and they were also ordered to file compliance affidavits within 6 weeks. The court also held that such cameras must also be equipped with night vision and must necessarily consist of both audio as well as recording of the video footage. In another landmark ruling, the Supreme Court decided to talk about Hecklers' veto. In the case of Amish Devgan versus Union of India, the court held that merely a hateful speech will not invite prosecution under section 295A of the Indian Penal Code. For this to invite punishment, not only should it be a hateful speech, but it should also be made with the malified intention of causing or inciting the religious feelings of a particular group. The court in the said case also held that while determining the standards of who such a speech may instigate or have an effect on, the reasonable man's test will be considered. In the case of Shilpa Mittal versus State NCT of Delhi, the court held that offences under IPC that prescribed a maximum punishment of 7 years or more, but however did not provide for any minimum punishment, would not be considered as heinous offences, but would be considered as serious offences under the Juvenile Justice Act. The next case is crucial under property law. In the case of Imperia Structures versus Anil Patni, the court held that RERA in no manner barred initiation of proceedings by the allotters against the builders under Consumer Protection Act. The court admitted that even though RERA provided for recognition and enforcement through a particular mechanism, however, it did not in any manner should be read so as to bar the remedy under Consumer Protection Act. The next case is again relevant under property law. In the case of Vidya Drolia versus Durga Trading Corporation, the Supreme Court held that any disputes that arose between a landlord and tenant under the Transfer of Property Act could be arbitrable, except when they were covered by a specific forum or a remedy created by the said rent control laws. The basis for this decision was that the court believed that such actions were actions in rem, but they did pertain to subordinate rights in personam and hence they arose from the same. The court, while doing so, overruled its own judgment in 2017 named Himangini Enterprises versus Kamaljeet Singh Ahluwalia. That's all for today, guys. I will continue with more judgments in part 2 of this video. I hope you liked the video and learned something new. If you like my content, please like, share, comment and subscribe to my channel Legal Banter. Thank you so much for watching and do hit the notification bell if you want to stay posted on such videos.